What? Hold on, hold on. Go ahead.
Okay, we are live. Good afternoon. This is the Board of County Commissioners. This is a quasi-judicial hearing. It is Thursday, August 31st, 2023. It is 1:33 p.m. This is set to go until 2:30 p.m. This is a hybrid meeting. We're at 3000 Pacific Avenue Southeast, room 110. For public virtual attendance, you may follow along on the Thurston County YouTube channel. The Thurston County Board of Commissioners is now on the record in an appeal filed by Mr. Magnum of High Definition Home LLC HD of the hearing examiner's decision dated July 13th, 2023, which denied him a reasonable use exception, RUE. The date is August 31st, 2023. Seated to my right is Commissioner Ty Menser, and seated to my left is Commissioner Gary Edwards. And I am Commissioner Carolina Mejia, and I'll be presiding over today's hearing. The applicant, HD, or High Definition Home, requested approval of a second reasonable use exemption for the subject property located at 5747 Capitol Forest Loop Southwest, Olympia, Washington, 98512. The original owner of the subject property, Mr. Bitmar, applied for and received an RUE in June of 2020 to reduce the wetland buffer from the required 160 feet to 50 feet for the development of a single-family residence, driveway, and septic system. 6 months later, before any development occurred in the property, HD bought the property from Mr. Bitmar and proceeded to construct a single-family residence in the location approved in Mr. Bitman's RUE. The current HD RUE is requested because when the single-family residence was constructed in 2023 by High Definition Homes, it encroached into the approach 50-foot buffer, leaving a 26 wetland buffer between the single-family residence and the wetland. Before a reasonable use exemption can be approved, HD must demonstrate there is no other reasonable use of the property with less impact on the wetland. The hearing examiner determined that HD's property already enjoyed reasonable use of his property because of the previously approved reasonable use exemption, which allowed a 50-foot buffer to accommodate the proposed residence with less encroachment in the wetland buffer. HD challenges the hearing examiner's decision, arguing that, first, the hearing examiner erred by finding and concluding that a reasonable use of the property other than the existing residential home is possible. No evidence, let alone substantial evidence, supports this finding or this conclusion. The only evidence produced demonstrated that removal or modification of the existing home would result in severe detrimental environmental impact to critical areas and buffers. Harming critical areas is contrary to Thurston County Code 24.45.030 and the purpose of environmental review. Second, the hearing examiner correctly found and concluded that the only reasonable use of the property is a single-family residence. However, she erred by finding and concluding that the proposed use of the property is not limited to the minimum encroachment necessary to prevent denial of all reasonable use of the property. This was error because removal or modification of the existing home would result in severe detrimental environmental impact to critical areas and buffers. Under Thurston County Code 24.45.030, it is not reasonable in this case to require an increase in the length of an existing setback from the existing home, nor is it in line with the purpose of environmental review to require such action. This is because all evidence demonstrated that the work required to increase the present setback would cause severe detrimental environmental impact to the critical areas and buffers. Third, similarly, the hearings examiner interpretation of Thurston County Code 24.45.030 produces absurd or strained consequences and results. Nothing in Title 24 nor in any Environment Review Authority supports denying a reasonable use exemption to cause a severe and detrimental impact to critical areas and buffers in the name of somehow protecting them. Rather, Thurston County Code 24.45.030 imposes necessary and often costly mitigation conditions that must be met. The hearing examiner had authority to require such mitigation conditions and even costly conditions as required, but she had no authority to deny this application that met all elements of Thurston County Code 24.45.030. So the issue before the board is whether High Definition Home LLC's application for a new reasonable use exception met all the requirements of the Thurston County Code 2020.45, including the fundamental criteria that no reasonable use with less impact on the critical area or buffer is possible considering High Definition Home LLC's revision and the project design by adding additional mitigation, Thurston County Code 2045.030. So commissioners will, at this time, I will ask each commissioner to make a declaration for the record regarding whether anyone has had ex parte contact with the applicant since the appeal was filed on July 20th, 2023. Commissioner Menster, we will start with you.
I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Thank you. Next, Commissioner Edwards.
I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Thank you. Next, it'll be me. I have not had any ex parte communication with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. Do any of the parties here have any objections or challenges for any board members to decide this case?
No objections from HD Homes. Andrew Mazzeo here representing High Definition Homes.
Thank you.
In the room, any objections?
Okay. So we will move on to oral argument by parties. The applicant, High Definition Home LLC, has an opportunity to present 15 minutes of oral argument. Oral argument may not present new information or evidence, but must be limited to the evidence in the record and the specific issues raised in the applicant's appeal. And then I understand the department will not be presenting oral argument, but is available to answer questions from the board. The board, if it has any questions, will ask them of the parties during or after argument. Do any of the parties have any questions before we begin oral argument?
Not from High Definition Homes.
Okay.
So, Mr. Mazzeo?
Mazzeo, two Z's
Mazzeo.
make a T like pizza.
Okay, thank you.
You're welcome.
You have 15 minutes, sir. Go ahead.
Thank you. So HD Homes is owned and operated by Kellen Mangan. He's been doing this for over 10 years. If you read the transcript, I did file that and provide that, took the time to get that over to you guys. He's been doing this for over a decade. He's done hundreds of homes in Thurston County, including, my understanding is in this neighborhood. He self-reported this mistake, that was this 26-foot setback, which is supposed to be about 50 feet. It's been a costly mistake. He had to take out a private loan because the bank called the loan on it. The evidence in this case is not supporting of any malicious act or any purposeful malfeasance by Mr. Mangan. It was staff reported as a mistake. All of the evidence, and it's a substantial evidence review, shows that it was a mistake. There was a neighbor that's talked about when Kellen testified that was claiming adverse possession. He was trying to make some accommodations for that. He walked the property with contractors and subcontractors. Neither the county nor Kellen caught this mistake before it happened. And Kellen hired a costly and specialized environmental consultant to come up with mitigation to repair this mistake and to cure this best he can as to the wetland infringement. Unfortunately, removing the home or doing anything but what staff approved as mitigation measures will ultimately destroy the wetland farther. It's, you know, when you're looking at ordinances or you're looking at any type of statutory authority, including local, you want to interpret it in a way that doesn't it affects the intent of the authority and doesn't produce an absurd result. And in this case, although this mistake has been made, further damaging this property or this wetland in the name of protecting a wetland, it doesn't make a lot of sense. And that's kind of a common sense argument here. I'll note at the hearing examiner at the hearing, if you read the transcript in chronological order, before Kellen even has a chance to testify, and this is the transcript at pages 19 and 20, she states, RU conditions were simply just ignored. She goes on a little bit and she discusses this hypothetical situation, essentially, of if a builder had purposely or maliciously ignored environmental regulations, then granting a reasonable use exception could invite that to happen again in the future. Well, that's not the case in this case. In this case, there's no evidence supporting malicious or malfeasance actions by Mr. Mangan. And the statute itself doesn't discuss or contemplate dealing with that type of situation. It talks about, uses the word shall, which is a mandatory command. If these elements are met, then they shall do this. And then the decision, the hearing examiner herself says that the elements of this ordinance are met, except for, she talks about this is what caught my attention when I read the decision for the first time. A reasonable use with less impact on the critical area or buffer is possible. Well, it's not. If you remove the home, you're actually going to destroy the wetland. The machinery involved to do that. And she goes on to say, although the hearing examiner is mindful of the applicant's arguments regarding environmental impact of removing existing development, as well as a significant unbudgeted expense, if the present illegal development were considered the baseline for determining impact. And then I put this in emphasis in my memorandum. Property owners would be rewarded for ignoring critical area permitting requirements because it would have been possible to establish a reasonable use of the property with less encroachment in critical area buffers. The criterion is not satisfied. Well, property owners would be rewarded for ignoring critical area permitting requirements. There's no evidence in this case. The county walked the property, Mr. Mangan walked the property. Nobody caught this. It was a mistake. There's no purposeful action here. And while I think it's well-meaning, what she's saying here is that we don't want to encourage this type of behavior when it comes to damaging wetlands. What do you do when it happens? If it is a mistake, does the statute give her authority to impose some type of punitive conduct? Well, I think it does in the fact when it comes to mitigation. It can require that you have to mitigate what you've done. And in another case where the evidence supported a contractor or a builder actually doing something with malfeasance or a malice or an intent and not a mistake, that might be another case for another day. And I think that I don't think that statute even contemplates those things. Now, if you purposely violate an environmental statute, there could be criminal ramifications, there could be civil fines, there could be things like that. But that's not what we're talking about at this procedural hearing. We're talking about whether a reasonable exception is met. I also think at the hearing, I cited a case, Hart v. Houghton, and that was a case that I took up on an appeal. And it talks about due process, and what due process is meaningful opportunity to be heard at a meaningful time in a meaningful manner. And in this case, and I'll start with Houghton's case. In that case, the judge, Judge Hirsch, she came off the bench and she ruled before hearing from the parties. Now, Division 2 found that a due process violation. And you have something that is similar to that, kind of smacks like that, doesn't really show the spirit of a fair hearing when before hearing from Mr. Mangan, she's saying that the rule requirements were simply ignored. The staff report didn't mention that or come to that conclusion. To have a fair hearing, you want to be heard and then have a decision made. And that's the essence of due process. I'll go on a little bit and I'll answer any questions that you may have. But the essence of this is that self-reported mistake, it's a costly mistake. All of the elements of this reasonable use exception are met. And it's for a legislature. The decision was interesting in the fact that she talked about how she didn't have jurisdiction and equity to do anything else. And at one hand, in the transcript, she's saying that these things were just ignored. And then on the other hand, she's stating, well, I don't have any equity. I don't have any power or authority to grant this exception because it's fair to Kellen. So she's kind of, I wasn't clear on what her ruling was there. Did she find that he purposely did this, or was she saying, you know, I feel bad that I can't grant this because I don't have any equity jurisdiction? That was kind of an interesting point there. But I think the easy thing to do in this case is just follow the words of the statute. The words of the statute are, if you meet these requirements, you shall do this. The decision goes on to say that if this was reversed on appeal, then that's an interesting thing to put into a decision. I don't often read that. That the mitigation requirements should be required, and that's exactly what Mr. Mangan has asked from day one. He self-reported this. He's happy to take care of the mitigation and do whatever he needs to preserve this wetland in and around the site or somewhere else. He's asking for a reasonable use exception. I believe that the elements are met for it. And to the degree that the hearing examiner found that he did something malicious, I don't think substantial evidence supports that. I appreciate your time. I'll answer any questions.
Thank you. Questions? Commissioner Edwards?
Yes. Did the county conduct a final occupancy inspection on this residence, or did it ever even get done? I haven't heard that portion or didn't see that in the record.
I'd have to talk to Mr. Manning. I believe that there is someone living in the property and that there may have been some expiration of the ability to do that. I'm not entirely sure. I'd have to talk to Mr. Mangan. I believe he is on the phone. I could.
No, okay. It's not that crucial, but if it worked out that I got that answer. How about, was there a? Pardon. Go ahead. Excuse me.
I believe the answer to your question, I'm just going to check my text message here. The answer is yes.
So the county did sign off on this as a completed project?
That's my understanding. I just got a text message from Kellen.
Was there a silt fence put up when this project started as required?
Oh boy, you're asking an appellate attorney to
Excuse me, Drew.
Answer. Go ahead.
You guys mind if I jump
Kellen.
in here for a second? This is Kellen Mangan, owner of High Definition Homes.
So then we need to continue with the time now. Hold on, we need to start the clock again. You have 5 minutes and 28 seconds left So go ahead.
Just to answer Mr.
I didn't hear
Commissioner's
that
question.
answer, sir.
The answer is yes, we did install erosion control with silt fencing around the property. And any soils that were exposed, we came back and put straw over the top of them
And
to
during,
prevent any erosion.
okay, and during the process of this project being built, was it regularly inspected by county staff in their normal process?
Yes, every foundation, framing, insulation, every inspection throughout a normal single-family residence, all the inspections were signed off by the county. And I have records of that. It's also a public record. And we did receive a temporary certificate of occupancy on December 21st, 2021.
Okay, and I think this is my final question. Could you give me a rough estimate of your total investment in permits, fees, and appeals up to this point?
I think he's got to calculate that. It might be large.
That's a tough one to say because having to take out the private financing as well.
Well, that would be part of it. I'm
Okay.
just roughly curious.
If
don't
I
think it's
calculate
legal.
that, I'm probably out over $100,000.
Holy, okay, thank you.
Commissioner Menzer, questions?
Yes, so I understand the issue of the good faith or lack of intention. I understand that there's a piece in the code that says if it's a self-created hardship, you know, that can be disqualifying. Aside from that, what is the relevance to us in this decision of whether this was a mistake or not? Is there other
Well,
things
the relevance to that, Your Honor, is when you're reviewing a hearing commissioner's decision or any any finder of fact.
Oh.
Yeah, I think somebody froze.
Council.
Mr. Megan, can you hear me?
Owner would be rewarded for ignoring
You
critical
froze.
areas.
Sir, you may want to start again, since we lost you for a few seconds.
About 30 seconds, maybe.
Oh, I apologize.
Yeah, can you?
Am I
please-
coming in okay
Can you
right
please
now?
restate again, the answer to Commissioner Menzer's question?
Madam Chair, could I say something here? Sir, is there any chance, I run into this once in a while when I Zoom and I shut the camera off during crucial times when I'm talking. It seems like it takes up less bandwidth. Could you do that just for a second?
Yes, sir.
I mean, just see if we can it's important to hear you.
Yeah. Happy to do that if this comes across better, less bandwidth.
I
wanna
think
make
it's
sure I'm
better
clear.
now.
Okay, so the mistake comes in because what you're reviewing is the findings of fact and the conclusions of law. And so the standard is, do the findings of fact, are they supported by substantial evidence? And if they are, is the conclusion of law compliant with the written law and applied to those facts supported? And here she's made a finding, and she says if the presence of illegal development were considered for the baseline of determining impact, property owners would be rewarded for ignoring critical area permitting requirements. Well,
Excuse me, do you mind
I don't know
if
how you read that other than saying that she's saying that Mr. Mangan ignored critical area permitting requirements.
Can
I don't
you,
know.
I'm
there's no-
sorry, can you let us know which page you're talking about?
That's her finding of fact. So if you go to the her decision, let me pull it up real quick.
Which section?
So if you go to page,
Her decision starts on the tab B.
yeah. So it's a 9-page decision, and I'm gonna go to it's conclusions based on findings, and it's on page 8, and it's number 3. And this is the critical conclusion of law. This is it. This is the big enchilada. And what she says is if the presence of existing illegal development were considered the baseline for determining impact, property owners would be rewarded for ignoring critical area permitting requirements. Well, who are the property owners? I mean, she's not a legislature. She's not trying to make a decision for the population at whole, right? Property owners, if you want to apply that to the facts of the case, that's Kellen. So she's saying that if I rule in favor of Kellen, then he'd be rewarded for ignoring critical area permitting requirements. And I'm challenging that. I'm saying there's no substantial evidence to show that Kellen did anything malicious here. He didn't ignore those. There was a mistake made. As we were just talking about, the county went out there, Kellen went out there, the environmental team went out there. Nobody caught this. So, I mean, she's making a decision on a hypothetical there. And it's just that the statute doesn't contemplate that in my estimation. She says property owners. Well, she's not a legislature. She's conducting a tribunal over specific facts to a specific case, specific findings, and you can replace the words property owners with Kellen Mangan, HG Homes, and if you do, Kellen Mangan would be rewarded for ignoring critical area permitting requirements. And they're just that the standard on appeal is substantial evidence, and I don't see the substantial evidence of that. I see mistakes made, yes, that the county didn't catch them either, and so she's saying that I don't want this to happen in the future, so I'm going to punish Mr. Mangan. And then she kind of talks about how she doesn't have equity to help him. So I'm not clear on what she's ruling there. I mean, it seems like if you replace the words property owners with HG Homes, she's saying that he ignored it. But then she goes on to say, I don't have any equity jurisdiction. Well, the inference there is that if I had equity jurisdiction, I'd approve it because I think it's not fair to him.
So that segues into my next question. Do you believe that this board sitting as we're sitting has any additional equitable power or jurisdiction than the hearing examiner believed that she had? Is there
No,
any...
you just follow the law. You just follow the statute. It's a shall. If the requirements are met, you know that's what we're saying. And the start of that conclusion of law, it's like the only element she says that isn't met. A reasonable use with less impact of the critical area or buffer is possible. No, it isn't.
Okay, so let me, you nicely segued into my next question. So you're right that she seems to focus a lot on criterion B, and I can understand the argument and potentially, you know, accept that. What I'm having trouble with is criterion D, because B talks about impact, and then you've got this debate about whether or not the baseline can be the building as it was built in error versus some pre-existing condition that the hearing examiner was looking at. And there's also a question of, I think you've got evidence, you didn't mention it in your argument, but I think you've got evidence in the record that there is no greater impact based on where the house has been built. So I think you might be able to get through criterion B, but I'm worried about D, which seems a lot more, a lot less subjective when it says the proposed use is limited to the minimum encroachment. And that has nothing to do with whether there's greater impact at 50 feet or 25 feet. I mean, the minimum encroachment, I guess I want to throw it to you. How do you argue that you satisfy criterion D so that we have this, you know, shall legal imperative criteria met, we grant the RUE?
Give me one, if you don't mind, just give me 1 second. Criterion D, what you were saying.
D is in dog.
D is in dog, I understand. If I read that statute, I don't think it uses the word baseline. if I read that ordinance. So she's kind of creating this, if that was the baseline. Well, the baseline is how the proper, you, obviously the statute contemplates something's out of whack, because you're applying for a reasonable use exception, right? Something's out of whack. So the question here is does he meet that element of section D? And I believe you can't, the statute doesn't contemplate winding back in time and holding him to a standard from the original setback. The mistake was made. That's why this isn't the first reasonable use exception application, it's the second. And the reason he has to do it the second time is because he made a mistake. And now I understand her not wanting to reward, property owners that purposely do this, but that's not the case here. That's kind of the crust of our a portion of our appeal here.
That seems
I
to
hope
be.
that answered it.
Yeah, I mean, it's interesting. That seems to be the key question about what you called it winding back in time, and that seems to be really it. Because if you should or you do wind back in
Yeah.
time, then
Yeah.
you can't meet
Well,
D. You
so-
can't meet D. But if you can't, but if you're right that you shouldn't wind back in time, so to speak, then I see where you're going. But I
Well,
don't know the
and
answer to
sometimes
that.
when you're looking at statutes like this too, sometimes it helps to use tenets of construction. And one of the most kind of in your face tenets of statutory construction, and I know it's a local ordinance, but still it's authority, right? It all applies, is you don't interpret a statute for an absurd result. And the purpose of, so if you have two possible meanings, right, in a statute, if you're going to interpret it, if there's a fork in the road and you're going to go one way versus the other, you don't interpret it for an absurd result. And the very purpose of environmental regulations, right, is to protect the environment. And if you're going to interpret a statute and require this guy to go tear up the wetland, I can't think of a better argument to say that that's an absurd result. Now, the legislature could come back and modify a statute or create a new statute and address these types of concerns. But what you're faced with is the statute before you. And when an environmental statute, the intent here, and the environmental guy gave me this. He goes, the purpose of environmental review is to provide no net loss of wetland or other critical area functions and values. To effectuate this purpose, TCC 2445030 provides that a reasonable use exception shall be granted by the hearing examiner if all the criteria are listed. Well, you got a fork in the road. Are we going to interpret this statute to cause more environmental damage, or are you going to interpret it to not? And now, if there's another, if there's to the degree that there's a civil penalty or a criminal penalty to ignoring things, Mr. Mangan just said that it's cost him over $100,000. I think he's paid the piper, but that's a different case, right? We're just saying the reasonable use exception. What the hearing examiner had the authority to do is say, hey, you made a mistake. You meet the requirement here because I don't want to have an absurd result of damaging the environment more. But what I can do is I can make you pay for the mistake with mitigation. And that's why Mr. Mangan hired the environmental consultant. That's why he has put forth this plan. And that's why, quite frankly, staff approved it or submitted it for approval with a recommendation to approve.
Thank you. Okay, I want to go back to Hart versus Houghton, and I believe you wrote in your memorandum, I believe it's on page, it's on page 10. And so I'm wanting you to possibly kind of expand on that.
Sure. Well, Hart v. Houghton, that was my case. I represented Mr. Hart. I took it up on appeal. I sat before, the commissioner there, and I had, in that case, what had happened is that there was a commissioner that had made a decision, and, possibly or theoretically, Judge Hirsch had reviewed it and then came out onto the bench. And what she said is that she essentially made a ruling without hearing from Mr. Hart, or Mr. Houghton, actually. Hart was the lady. I apologize. This was years ago, but I do remember the case, and I've read it a few times, the decision. And the analogy here is that if you read that transcript, Mr. Mangan did not have any due process. What is it? It's the most fundamental thing that any judge or any lawyer can protect. It's, I don't want a star chamber. I don't want someone to rule on something and determine my fate without hearing from me. That's what it is. It's the most, without that, you got nothing. You get an opportunity to be heard before someone makes a decision. That's what we're doing today, right? We're getting an opportunity to be heard. Everybody says their piece, and then you make your decision. And when you read that transcript, and as well-meaning as she may have been, before she hears from Kellen, she states the rule requirements were ignored. That's a finding, essentially, right? And then if you look at her conclusion of law that we talked about, she essentially codified it. She wrote it down. And that's just, it doesn't smack as fairness. So due process is essentially, was it fair? Did you have meaningful opportunity in a meaningful place to be heard? And if she's already made her mind up before the hearing happens, and that's what that record shows, right? She says, the Rue statute was ignored. And then she goes on to say about how I don't want to reward people that purposely ignore these things. And I find that to be analogous to Houghton, where you're making hear from people. That's what being a judge is. That's why you put that robe on. Is you hear from people, you hear the arguments, you let the facts lead you to the decision. You don't backdoor it. You don't make your decision and then justify it with the facts afterwards. And if you haven't heard from Kellen, it doesn't seem like you're giving him a fair hearing. It doesn't seem fair. And that's what due process is. Does that help? I'm happy to expand.
Not really the angle I was aiming towards, but I think just that will do for now. Commissioner Edwards, go ahead.
I'm just trying to clarify something here, counsel. Apparently, you're thinking the hearings examiner, although well-meaning, meaning she maybe did not have the authority, or she didn't feel she had the authority to rule in favor of the applicant. But you do feel that this Board of County Commissioners has the discretion to do that? Is that what you're thinking?
Yeah, so it's a little bit, our courts are, in the old days, back in the English common law, you had courts of law and you had courts of equity. They were two different places. You're talking about people that, didn't have pens, didn't have typewriters, didn't have computers. So there wasn't a lot of written law. They had some written law, but it didn't cover everything. So if it didn't cover it, you went to your noble person, you said, this ain't fair, what can you do? That's a court of equity. She's talking, I don't know why she's talking about a court of equity in her decision, quite frankly. My application here and my appeal has nothing to do with equity. I'm pointing out that it's an absurd result, and I'm pointing out that the statute says shall. If you meet the requirements of this, then you shall grant it. Now she brings up, well, I don't have equity jurisdiction to do something that's fair. I take the equity out of it. I'm not relying on equity in any way, shape, or form. Now it's in the background, right? But the Court of Appeals has already ruled that the hearing examiner doesn't have any equitable jurisdiction. It's because they're an executive agency. They're pure, they're a statutory beast, right? Equity comes from the common law. And when you have an executive agency, there is no common law behind it. So you can't have equity. That's where the Court of Appeals decision comes from there. But what I'm saying here is that the law says shall grant if you meet these exceptions. Now, the previous commissioner talked about the fork in the road. That's where we're going. right? Is it, what's the baseline? Baseline's not in the statute. It's just a shall do you meet these things, is my understanding. So I'm relying on the legal arguments. That I'm not asking you, it's, oh, I want you to do the fair thing for Kellen. No, 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 that is not my argument. I agree with the commissioner's statement of law there. I just don't think her talking about it mattered. I think it was interesting to me because she seemed to make a finding that said that Kellen purposely ignored things, but then she also said, I don't have equity, I don't have fairness to make this right for him. So she kind of backtracked a little. It just seemed odd to me. I wasn't quite clear on what her conclusion of law was there, other than she said that it doesn't have equity. But she seemed to rule that, again, if you replace property owners with Kellen Mangan, she's saying Kellen Mangan purposely ignored this. Well, if he purposely ignored it, why are you talking about equity?
I have a question for staff. Thank you.
Brett Burris, Development Services Manager with Community Planning and Economic Development.
Thank you. Brett, I kind of wanted you to touch on, I guess, the section 4 from the decision, and it says that there were some staff suggested conditions for mitigation, and I'm just hoping you can kind of touch on that and, you know, just that whole process of how we got to that point. And go ahead.
So when a reasonable use exception application is submitted, one of the requirements is a mitigation plan. And that mitigation plan is done through an environmental consultant reviewed by staff to determine if the appropriate mitigation is being met to meet the criterion of no net loss of functions and values.
How is that no net loss measured?
It's measured by mitigation, the plantings. Essentially, the mitigation applies to the impact of the development. So if you think of a vacant piece of property, you put a single-family home, a driveway, and a septic system in it, that impact can be measured, and that mitigation plan is used to reduce the impact to the point of no net loss.
Okay. And so the staff recommendation of requiring additional trees to be planted between the residents and the McLean Creek Natural Area, is that still staff's recommendation?
Yes.
Thank you. Any questions for Brett while he's up here so he doesn't?
No, ma'am.
Thank you.
Thank you. Okay, any additional questions?
No, ma'am.
You have 3 minutes and 50 seconds left. Is there any thing you would like to add before we conclude the hearing?
I have nothing else, Your Honor. If you have any, the commissioners, I have nothing else. If you'd like to ask me some questions, I'll answer them. But the briefing is laid out there. I'm not relying on equity. I'm relying on statutory arguments. Equity involves a judicial branch of the office. This is an executive act. There is no equity. I agree with the hearing examiner as to that. I just find it irrelevant, and I find it confusing that she's talking about equity when she seems to be finding that Mr. Mangan purposely ignored things, and there's not substantial evidence to support that. And I think if you're at a crossroads, so to speak, or a fork in the road, interpret the statute that protects the environment to protect the environment.
Thank you. Okay. So thank you, everyone. The board will issue their written decision on or before September 13th, 2023. It is
2:17.
2:17. This hearing is adjourned.